for joining us. Just noting to presentation today is coming from 3%ers on the lands of the Bodarong people. And thanks for taking the time to join us. We're going to have three presentations today. As you can see on the screen, Rob Warnock and Caitlin Loudon are going to speak about small businesses and CGT concessions and family trust elections, respectively. Though first off, I'm going to talk about the use and structuring of appointors and appointor provisions. Breaking that down into really three sections: how the role has traditionally been understood and used, how that role's been expanded over time and how we're continuing to use it in more diverse and different ways, and then particularly the use and structuring of corporate appointors and becoming certainly much more in vogue as time goes on. So a little bit of the very, starting at the basic background and expanding out from there. Obviously we have a few key roles under discretionary trusts. Initially, we have the beneficiaries, so the people, the eligible objects who have the right to be considered for distributions of income and capital, among other rights. The trustee, in whose name legal title will be registered, and we will have the day-to-day administration of the trust. And then I've broken down the next role into two parts, notwithstanding that they've now largely been blended. So the historic position tended to be that we had a guardian role. And the guardian tended to be more of a patriarch, matriarch, or a combination of the two, really looking after the affairs of the family. So the clause that's up on the screen there is a clause from a trustee of that era, a relatively common clause, and particularly it would break down and start using the concept of reserved powers and restricted powers, and prohibiting the trustee from exercising any of those powers without the consent of the guardian. Interestingly, you would get a lot of clauses that's similar to this one, specifically saying that where you have a guardian at the commencement of the trust and that guardian may cease, then the reserved powers can't be exercised by the trustee, which obviously presented some issues over time. And historically, there weren't necessarily great succession roles within the guardian clauses. Separately, we had the concept of an appointor, and the appointor was simply, more often than not, just removing and replacing the trustee. So again, the clause that's on the screen there at the bottom is not particularly dissimilar from the clause you'll see in most modern deeds, and as will come up a bit later on, it's relatively similar in flavour to our current clause now. Important point to note as well is that while we have the Trustee Act of 58 in Victoria and we have the analogous legislation throughout states and territories, across the land, appointors and guardians don't have a governing act per se. We have plenty of common law, judge-made law, and there'll be provisions within the trust deeds about the rights, powers, obligations, restrictions on appointors and guardians, but there's no governing act itself, as it is for trustees. Over time, then, we've seen the blending of the two roles, and other than in the self-managed superannuation fund space, you see relatively few guardian clauses these days. So while the appointor still has the ability to remove and replace trustees, and as I said, that's relatively similar to the clause from the previous slide, we trustees needing the appointor's consent to varying the deeds before exercising certain powers, before nominating particular additional beneficiaries, remuneration clauses, distribution restrictions, and then bringing forward the termination of the trust, and in the context of our deed and quite a few others, even after the trustee has obtained the appointor's consent to terminate the trust before the end of the perpetuity period, we then have an additional obligation to provide accounting reports to the appointor. So that concept of the guardian and the appointor being separate roles has now really been almost universally blended into one. In terms of how then we're understanding what the powers of the appointor are in the succession of that clause, the relatively common position will be, and let's just assume it's two people for the purposes of this clause, it'll be A and B, and on the death of the survivor of the LPR of that survivor. So stock standard clause that we will have seen 1,000 times. But then whether on considering then in the provisions of the deed itself, what actually may happen on the occurrence of certain circumstances. So on our deed, for example, if an appointor is suffering particular events, so here you'll see elements of bankruptcy, encumbrances taking possession, but also later on in that clause where there is an incapacity of the appointor, or in the case of the last point, potentially a deemed incapacity of the appointor, an appointor ceasing in that role, you have the ability for appointors to remove and replace themselves. And this is just sort of almost an aside to the presentation, but is an important clause to check in the deeds. A lot of people will assume that appointors have the ability to appoint successive appointors. There are plenty of deeds where the power is simply the ability to remove and replace, not to then set out a cascading successive appointor lineage. Most deeds will have a similar clause to ours where the appointors are effectively appointed jointly. And then it's effectively the same as the right of survivorship under estate provisions, where if you've got multiple people appointed and there's nothing to the contrary, then once one of them ceases, the other will continue on solely. And then the last point there, the death of the sole appointer, really aligning with that point in the top left, that if there's no otherwise replacement, it will be the LPR of the surviving appointer. So from an appointer structuring, obviously I showed a few of those clauses in our deed that we have as a relatively normal or starting position, but then the expansion of the role and how we're using it from a structuring perspective in particular. So as I said, you've got the standard starting position, but people are now often looking into a family succession. So we're saying it may be A and B. So in this case, let's assume it's parents. And on the death of the survivor, it might be that their children are taking over at a particular age. So in this case, 25, but really whenever we want the children to come in. Again, when we're using those sorts of clauses, you can expand those out further to say, well, what happens if the children are minors or under the age of 25 in this context? When the survivor dies, who might come in to replace them? Should a power of attorney come in? Should a legal personal representative come in? If a child commences in the role and then ceases, should we have someone coming in there in their place? And that obviously brings in questions about often non-blood relatives. So it will regularly be a spouse of a child will be an LPR or an EPOA. And obviously that person's an in-law of A and B in that scenario. Could be friends, could be advisors. The point being it could expand well beyond the initial family group, or alternatively, whether we have simply no replacement for them at all. The use of independent appointors has been relatively common historically, but it's now sort of expanding further. So the idea of independent, and I love the word independent, it's one of those very malleable words in the legal industry. Independent could be actually very closely related. It could be a sibling, a parent, another family member. It could be friends and colleagues. You do run into scenarios where using colleagues or advisors can have issues at times. An example I have quite recently is that two people working together and a business partner at the time was an independent appointor, and their businesses simply grew apart over time. They didn't sign the necessary documents, and at the moment we're trying to track down somebody with whom our client has had no contact for over 30 years because they need to sign off some documents because they were put in there for a structuring perspective in the early 90s. The other role that's becoming more common among advisors, lawyers, accountants, and financial planners in particular, is the use of an independent where there's specific succession within a firm for that independent. So, for example, if it were Harwood Andrews, it might be that we're appointing an individual here, but if that individual isn't able to take on that role or ceases in that role for some reason, death or incapacity primarily, that the firm would have the ability to appoint somebody in their place so that then we have that succession of the independent role locked in over time. And then the other point, which will be the sort of the last section of the presentation here today, is the use of the corporate appointors. The ease of that section being there's no nuance or complex drafting to the succession. It's simply the name of the company that's being put in the deed. One of the other points that's quite salient to the use of corporate appointors is the difficulties around capacity of individuals. So obviously, as medical science gets better and better, we unfortunately all know people in the family tree who've suffered Alzheimer's, dementia, or otherwise had capacity questions. The body continues on, but the mind potentially not so much. So linking back to that clause I put up earlier from our deed, and particularly subclauses 6 and 8 there, we start talking about whether or not the appointor has capacity. And then that obviously leads into the question is what is capacity and when is it lost? So we have a legal definition of capacity and a medical. and the difficulty oftentimes of the individual who's in the role maybe not agreeing with other people about whether or not they have capacity. The nuance around capacity as well being that it will be task specific and fluid. So I may not have had capacity yesterday, I may not have capacity tomorrow, but I may have it today. And I may have capacity to give a presentation, but I might not have capacity to prepare a trust deed. So it's always going to be quite nuanced. And in the case of Alzheimer's dementia in particular, we'll have plenty of people you've seen where that capacity changes a lot over time and is very task specific. On the incapacity points as well, there's two cases I just want to quickly highlight. I won't go into any great detail on because there's simply not time. But there's the Ash and Ash decision from the Victorian Supreme Court decision from 2016. In that instance, Mr. Ash did a wonderful thing. He had an enduring power of attorney in place, thought about the issue of incapacity and appointed his daughter. His daughter used, though, that power of attorney to remove her father as the sole appointer of the trust and appoint herself in the place. There was absolutely no doubt in that instance that Mr. Ash was incapacitated, and there was no suggestion the daughter was trying to do anything inappropriate. But here, importantly, there were no instructions provided. There's no evidence over time that Mr. Ash had intended the power of attorney to be used in that way. And there was then no instruction or direction in the power of attorney itself that he wanted it used in that particular capacity. So in this instance, the court held that the use of the power of attorney to replace the appointor was not a valid use of that power of attorney. The Harrison-Rothery decision's another really good one, separating out and pointing out that particular powers within a deed, even though it may be the same person having the same role, different powers may have different obligations on them. So in that particular decision, the court looked at the power under that deed to remove and replace the trustee and said that that particular power for the appointor was a fiduciary power, but that other powers within the deed that the appointer was able to exercise from time to time were personal and didn't have the same onerous obligation that the fiduciary obligations had. So obviously the important part there being reading the deed, but then also understanding from a drafting perspective what you're trying to achieve at appointor level, whether or not you're doing that through the deed itself or then through later documents such as variations or powers of attorney themselves. The expansion of the appointor's role is something that's obviously going to be bespoke drafting from deed to deed, but we're often seeing now that the appointor's consent is required before the trustee will make loans or distributions of capital, sometimes over a certain amount or sometimes at all. Periodically income distributions. Approval of financial statements and tax returns is a very useful tool where we have a larger group of people at the appointor level and maybe one or two key members of the family at trustee level. So there's effectively an ability to have at least an annual oversight of what the trustee is doing with the trust fund. Then there are also decisions in relation to business and property assets, and then those really the related party dealings. So you'll often see circumstances, and I have again a live matter at the moment where one of the sons in the family has taken an outsized level of control within the family group and is renting a very significant property to himself for nearly no money, much to the chagrin of his siblings who are also beneficiaries of the trust. So in circumstances like that, considering whether we want the appointor's consent to those sorts of uncommercial or related or conflicted dealings. That obviously then leads into questions about how the appointors may make decisions. So the vast majority of deeds will have unanimous decision making as the default position, but we may have majority decision making, and particularly it could be then expanding to whose consent is needed. So if you use the example of, let's say we've got mother and daughter as appointors and an accountant, it might be that the trust is being utilised to operate mum's business, and while we're happy to have the daughter involved in there and she may be part of the succession planning, we might say that the trustee isn't able to, the appointer isn't able to make decisions relating to the business by majority unless the mother's part of that majority. So the mother and the daughter can agree to do something, the mother and the accountant can agree to do something, but the daughter and the accountant can't effectively outvote mum. That then leads into corporate appointors. So as I said, they're becoming much more common usage these days. So let's set up a relatively basic family group with a number of trusts. So we've got a business trust, property trusts, an investment trust, so owning assets other than a property, and then let's say we've got a second property trust. We don't, let's say we've got two properties, we don't want them aggregated for land tax purposes, so we've put one property in one trust and one in another. So the common scenario, as I said at the beginning, will be that we have one or more individuals at the appointor level. So initially, obviously read the deed, read the deed, read the deed. Assume that we can have the power to appoint a corporate appointer as the appointer of the trust. If we can't, though, consider whether we have the variation power within the deed to allow us to do that. And remembering the principles in McCanty, which was a wonderful decision, really going through the intricacies of how variation clauses are drafted and how they can and can't be used with, in that case, very limited different wording, which had a very significant implication on whether or not the power could or couldn't be exercised. But let's assume that we do have the ability to do that. So we'll prepare an appointer change so that instead of the individuals, we have one company as the appointer of all of those trusts. And in this scenario, obviously consideration needs to be given to who owns the shares in that corporate appointer. But let's say for the purposes of this little diagram here that it's a separate discretionary trust that owns the shares. So if we look at a common structure here. So obviously the constitution needs to be tailored to each family group, but the common considerations you're looking at are who are going to be directors. So particularly within family groups and larger family groups, as they go through the generations, we may have one or more family members involved in a business and others who are entitled to benefit from, but we're not really meant to be controlling the business. So they might not be appropriate directors, whether or not independents come in there, the removal and replacement of directors, and then the same sort of conversations at shareholder level. What happens if there's death or incapacity? What happens if someone wants to transfer shares? How decisions are being made. So very much separating out sometimes strategic and business decisions from a wider family consideration, which, as I said, again, becomes much more common when you're looking at multiple generations and next generation starting to be able to get some benefit, but maybe having a smaller say within the family group. Where and how board meetings are being had, and whether it's board meetings or family meetings, and then how we can extract capital from within the group, and particularly if one family line or a couple of family line wants to leave. So I'll just finish up by looking at a particular example structure. So using that structure I had before, let's say we've got mum and dad within the family, and I'm less creative than a couple of the other people who are going to present today. So in my family, mum and dad are simply known as A and B, and the parents are X, Y, and Z. So in this particular structure, we've got the business trust operating a business, and it's the parents' business. They've grown it up over time. It's the family business. In this case, we'll say that X and Y have an interest in taking control of the business over time, and Z doesn't. Z's happily going off doing their own thing. So we will at some point have some succession, but mum and dad aren't really willing to give up the reins yet. The property trust owns the business real property from which our business operates. The investment trust, for the sake of the example, let's say there's just cash and shares in there. And the second property trust, a residential property that's so there's a bit going on there, but it's sort of a not uncommon structure from people who've developed a family business through a particular vehicle and then have sufficient assets to then invest as well. So in this case, for example, we might issue A-class shares to mum and dad and X, Y, and Z class shares to X, Y, and Z respectively. And what we'd often do in those scenarios is put different rights around when and how those people can appoint directors and how decisions are made at different levels. So for example, at shareholder level, we may give 51% of the voting rights to the A-class shares so that X, Y, and Z can't outvote A, even if they all agree. Similarly, it might be that A-class shares in this example, they have the ability to appoint the directors, but not the other classes, unless we have a parent cease in this scenario. So looking at scenarios of saying, well, if A or B cease, then maybe we do bring in X or Y, but we might still give that weighted voting to the parent so that the survivor gets to start bringing the children in who are meant to have a succession element of the business, but they don't necessarily get to outvote the parent at that starting position. In this scenario, though, we might say that we'll refer to family meetings as really those meetings and at shareholder levels and say, well, Zed might not have anything to do with the business and is absolutely not appointing a director and is not coming along to those business or strategic discussions, but there are investments involved within the structure and really the equity in the business and the property is meant to be shared within the family group. So Zed does get to come along to those meetings as well. And then looking at how, when, why X and Y might get replaced over time. So that point I made earlier about their powers of attorney, their estate planning, succession considerations, how they might be able to replace themselves. And then the last option being, or the last one for the purposes of this conversation being, how do we exit someone from within the group? So let's say in this scenario that X says, look, I love what the family's doing, but there's a chunk of equity here that's meant to come to me and I don't want that tied up within the family business structure. Then look at considerations of sort of what notice periods might we have, how might the business be valued and the interest be valued within the group so that then we can work over multiple generations to have people come in and out. I'll pass over now to Caitlin.
Thank you. So I'm going to talk about family trust elections. I think the reason why I think this topic is relevant is not so much because over the past year or so the ATO has indicated that it will be a bit of a hot topic. And in fact, I think the ATO is doing a presentation themselves next week on family trust elections. And it's also not because I think it's a particularly draconian set of provisions because of the way it gives rise to family trust distributions tax. Which, when it remains as this omniscient lurking shadow behind the trust forevermore, because there's no period of amendment. It applies both to the trust and if there's a corporate director to the directors of that trust, but also because it has this imposition of what equates to highest marginal rate tax on the amount of the distribution, combined with that soon to be non-deductible, assuming the legislation passes, general interest charge. So at the moment, the GIC rate is 11.4%. There's also nothing new about the length or the breadth or the complexity of the provisions. That has essentially been the case since the provisions were introduced. And Rob will soon be talking to us today, but about 30 odd years ago, he was presenting to the Senate Estimates Committee in respect of the family trust election rules. And he said that the cost of compliance with these new provisions was going to be astronomical and that it would be a boon for lawyers. Now, in this environment, that might not be seen as a bad thing. In fact, it might be a good thing. But with that comes a particular challenge for advisors. I was speaking to one tax advisor recently who said his biggest fear in life was advising on these provisions simply because of the consequences and the challenges with potentially getting it wrong. So with that particular stress and the ATO's renewed focus on it, there isn't anything new. But what I think does give rise to a reason to revisit these provisions is as a result of the new suite of provisions that will apply to tax agents or already do as a result of the changes in the past year or so. In particular, I think accountants very soon are going to have to do a lot more work to get to know new clients. And so I really question, in the case of a new client that includes an entity that has a family trust election or an interposed entity election, to what extent an accountant's now going to have to make inquiries in respect of the original elections that were made? Will it be sufficient to just rely on the ATO's records? Like, my experience is that those records are notoriously wrong. Will it be necessary to obtain the original form that made the election? Quite often they're no longer available because in the past the ATO requested the originals be provided to them and they no longer have them. What if the new accountant discovers that there's been past distributions that give rise to the application of family trust distributions tax for a new client? Do they have to dob in the previous practitioner? And if they do, what impact might that have on the new client, particularly if that distribution might have otherwise gone unnoticed? I don't have particular answers to those questions, but I think that gives rise to a reason to revisit the provisions. I don't have time to do a full 101 of the FTEs and FTDT provisions, but I'm going to try and fly through the basics with a particular emphasis on family group, and also the family control test. And then I'll focus on a few case studies. So why do we make FTEs and interposed entity elections? The main reason historically was about the utilisation of modified rules to access trust losses. But since the original introduction of the provisions, there's been a suite of other provisions that have relied on trusts making FTEs to give a modified outcome, usually a simpler outcome to the application of the rules. So for example, trustee beneficiary reporting rules won't apply to a trust that's made an FTE. In relation to the small business restructure rollover, if a trust has made an FTE, there's concessional rules in determining ultimate economic ownership. And also in respect of the franking credit trading rules, the beneficiary of a trust that's made an FTE will be a qualified person for the purposes of accessing those flow through franking credits, provided the other requirements are met. But with all those benefits of making an FTE comes with it the significant consequence if you get it wrong and make a distribution outside what is the family group. If a distribution is made outside the family group, that is when family trust distributions tax will apply. And it applies to the distribution. A distribution is fairly obvious in some situations. A present entitlement or a dividend or a partnership distribution will all be caught. But the meaning of distribution is given quite an expansive legislative definition. And that expansive legislative definition includes distributions to non-beneficiaries. It can include amounts that are paid by way of loan. It can include the transfer of property or the use of property. So making an FTE or an IEE can really inhibit the allocation of interests in the trust or the company to deserving outsiders. So for example, key employees or capital contributors. And it can also effectively make the entity unsaleable, because once that entity is sold, there might be new shareholders or other deserving contributors that can no longer receive distributions without the trustee being lumped with family trust distributions tax. So what are FTEs and what are IEEs? In order to make a family trust election, you have to satisfy certain tests. Those key requirements really are, you have to specify an individual whose family group's going to be taken into account. That individual is sometimes called the specified individual or the test individual or the primary individual. It's all the same person, it's just a slightly different terminology sometimes used in the provisions or by advisors. You also have to pass the family control test at the end of the specified year and satisfy the normal formalities. Subject to certain exemptions, the family trust election is generally irrevocable. And there's also very limited situations in which the test individual can also be changed. Some key things to remember before we look at the family control test is that the specified individual, according to the ATO, has to be alive at the time the election is made, and the trust can't make more than one FTE, even if an FTE has been validly revoked in the very limited situations where that can happen. So in order to make that family trust election, you have to satisfy this family control test. And what the family control test is, effectively, is that a certain person or group of people has to satisfy one of those 7 tests. And what those 7 tests broadly reflect is some degree of control over the test. The group changes depending on the test. So you can see there that if you're part of Group A, you can satisfy any one of those seven tests. If you're part of Group C, you can only satisfy test F. If you're part of Group B, you can satisfy A to E, but not F and G. In respect of Group A, the group of, or the certain individuals that we're looking to is the primary individual themselves having the necessary degree of control over the trust, one or more members of the primary individual's family, or a combination of those individuals. So it might be the primary individual with one or more members of the primary individual's family. In very small set of circumstances in relation to G, if you have a very narrow group of individuals who can benefit from the income or capital of trust, then you might satisfy this test. And that will be where that group of beneficiaries is merely the primary individual or the test individual and their family members. So that perhaps, the second one is Group B, and Group B is where you've got someone from Group A and one or more legal or financial advisors to that primary individual or the primary individual's family. There's a couple of unknowns with that though. One is what happens if you have a member of Group A who's a minor? Can that minor have a legal or financial advisor if they're unable to formally engage that legal or financial advisor and it's done on their behalf? So this might become an issue, for example, where the primary individual is a parent and they're deceased, as is their spouse, and so that all that remains is minor children. The other thing to have a think about is what is a financial advisor? Could that include a tax agent, or is it something more narrow than that? So who's in the group of the family? If you have a look at the diagram, it really sets out who it is, where the test individual there is in the green with the bolded blue box. And so what you have is the parents and grandparents of that individual, their siblings, their nieces and nephews and children, and all other lineal descendants, but also their spouse and the spouse's siblings, parents and grandparents. A person doesn't cease to be a member of the family merely because of death of either the test individual or any of the other members of the family. So in some instances, widows and widowers will remain part of this classification of family, but we'll also talk about situations where that might not be the case. And the reference to children there is quite a broad definition of children, and it includes adopted children, stepchildren, things like that. You'll see also there's quite a few asterisks. Those asterisks designate that those particular people include their spouses, and that can be a spouse by way of marriage or de facto or otherwise registered relationship. What it doesn't include is aunts and uncles or great aunts and great uncles of the test individual. But what you can see is that if you vary the individual who is the test individual, so they move up a generation, what you effectively do is expand the group who can be included in the classification of family. And so what we often see in practice is that often the oldest living matriarch or patriarch of a particular family will be the test individual without too much thought. But it's not always going to be the case that that is the right approach, because the older the person is, the more likely that there will be later restrictions on having that same person as the test individual of other entities, which might narrow the entities that you can have within the family group after the death of the test individual. So that brings me to the definition of family group. What you can see there are all the various classes of entities or individuals that can be part of this classification of family group. And it's outside of this family group where distributions outside this class of family group where distributions will be taxed with the family trust distributions tax. So some are fairly obvious: the primary individuals included in that, the primary individual's family members, and the trust itself, which enables for distributions coming back in some instances to be captured. Former family members of the primary individual or the primary individual's family can include ex-spouses, but it's also where there's widowers or widows who have remarried. Entities that are owned 100% by the primary individual's family members, or trusts with an FTE with the same primary individual will be included, provided it's 100% ownership. But with that comes a challenge with entities that are owned by trusts with a family trust election nominating a different primary individual. Another class of family groups is trusts with the same nominated primary individual. This is an important one because if you do have trusts with the same nominated primary individual, you don't need to then rely on making an interposed entity election, which has the potential to enable a broader class within the family group because of being able to bring in other entities. Charities in certain instances will be captured as well. Estates of the primary individual and the primary individual's family will only be included if all the members of the primary individual or primary individual's family are dead at the time of the distribution, and entities that have made an interposed entity election in favour of the primary individual. So that brings us to the interposed entity test. In this instance, a trustee that's made a family trust election can have another company or partner of a partnership or trustees of another trust making an interposed entity election to be included in the family group of the individual specified in that family trust election of the other entity. Again, it's generally irrevocable. The key requirements, again, are similar. You have to have a specified year. It doesn't have to be the income year in which it's being made. It can be an earlier year if certain conditions are met. It has to pass the family control test at the end of the specified year, and it has to satisfy various formalities. Now, there's a restriction on making multiple interposed entity elections, and so you can make multiple interposed entity elections provided that the trust to which those interposed entity elections are being made all have the same primary individual or test individual for those trusts. If there's different specified individuals, the interposed entity election won't be valid. And so again, it really comes down to this concept of passing the family control test. In respect of interposed entity elections, the family control test is almost exactly the same. What we're looking at is the test individual to the trust to which the interposed entity election is being made, the relevant test individual of that trust, its family members, etc., can satisfy the necessary degree of control over the trust which is making the interposed entity election. But the control test for companies and partnerships are a bit different. In relation to companies and partnerships, you have to have the relevant individual, their family, or a trust that has made a family trust election with the same nominated individual, all holding between them fixed entitlements to more than 50% of the income or 50% of the capital of the company or partnership. So if you think about this example, we have Bay and Zico wanting to make an interposed entity election to be included in the family group of Beyonce. You can have Beyonce holding the shares and more than 50% of the shares, Jay-Z, her spouse, or their children. You could also have the relevant trust to which the interposed entity election is being made. So Beyonce trust with the test individual being Beyonce, or any other trust that has the test individual of Beyonce. Where it gets a bit more difficult is where you have a trust, for example, Bay Management Co. It couldn't make an interposed entity election to be included in the family group of Beyonce, because in this scenario, we've got Beyonce holding 50% of the shares and her manager holding 50% of the shares. And in this instance, the manager is the aunt, which is outside the definition of family. Similarly, if Beyonce and Jay-Z held those 50% of each of those shares, if they were no longer spouses, you would, because they've ended their relationship, you might have challenges meeting that family control test, because once they're ex-spouses, Jay-Z would no longer be part of the family. Similarly, if there was an entity there that didn't have the test individual, being Beyonce, you would struggle to meet the family control test. So if we have a look at a particular example, still somewhat with that particular test, we have here Beyonce and Jay-Z. They each have their own trust, and they're the test individual of their relevant trust. Each of those trusts own 100% of the shares in a company, Bayco and Jay-Z Co, for the relevant classification of the two different groups. So in that fairly simple scenario, you can see that Bay Trust is going to be part of the family group of Beyonce, because it's a trust in respect of which a family trust election has been made, and she is the necessary test individual. Beyonce Co or Bay Co will also be part of the family group of Beyonce, because it's a company which, on the basis of this scenario, has 100% of the shares being owned by the trust, with the specified individual being Beyonce owning those shares. Assuming there's no interposed entity elections there, Jay-Z Co and Jay-Z Trust won't be a member of the family group of Beyonce. But let's just assume Jay-Z Co has tax losses, and let's assume Beyonce Co has a whole lot of income. One way to try and utilize those losses is to try and get the income from Beyonce Co all the way across to Jay-Z Co. Now, without doing something, that certainly wouldn't happen without the imposition of family distribution tax, because you couldn't have the flow through to what I'll call Jay-Z's family group, because it's outside the family group of Beyonce. The challenge is the only way that could happen is by having dividends flow from Beyonce Co to Beyonce Trust. Then you'd have that distribution of those dividends to Jay-Z Trust, and then another distribution to Jay-Z Co. And so you think, well, how could we potentially get around the fact that this, as it stands, would have family trust distributions tax? And you think, well, perhaps I could make an interposed entity election by Jay-Z to be included in the Beyonce group. There's no issue with those interposed entities being made, because in most situations, what you'd find in respect of Jay-Z Trust, there'll be somebody in Beyonce's family, or that will have the necessary degree of control over the Jay-Z Trust. That might be Jay-Z himself. But it might also be Beyonce, depending on the particular facts of the scenario. And so in those circumstances, those interposed entity elections ought to be valid. The challenge is that once you've made those interposed entity elections, you actually narrow the group of the family group that can be included in Beyonce or Jay-Z. And what we can't then do is make the interposed entity election by Bayco to be included in Jay-Z's family group, or vice versa, Jay-Z Co to be included in Bay Trust's family group, because the necessary control test for those companies will never be satisfied for them to be able to make interposed entity elections, because they will, because their respective shares are held by a trust with the other entity or the other individual being the relevant test individual. And so what you have is you have a denied deduction and also the imposition of family trust distributions tax. What's even more challenging is once you have that distribution of the family trust distributions tax, you actually lose the benefit of the franking credits, because the family trust distributions tax isn't actually the distribution flowing, say, to Jay-Z Trust in this situation. And so they won't have that entitlement to the franking credits that have come from Bayco. And similarly, Jay-Z Co will no longer have the necessary entitlements to have those franking credits once the imposition of family trust distributions tax has been imposed. And so there's a real issue there with double tax. I'll just fly through the last example before handing on, which is really to do with the death of an individual in the family and how that can cause complications. So in this straightforward situation, you have a husband and wife, Paula and James. When they're married, clearly the distributions to James by that trust, if Paula is the test individual of the trust, won't be imposed with family trust distributions tax. Let's just assume that Paula dies. Again, mere death, as I said earlier, won't cause a family to cease to be a member of the family. And so any distributions to James also won't be subject to family trust distributions tax. If James gets a new spouse, he's likely to cease to be a member of the family because it's no longer mere death. He's actually entered into a new spousal relationship. But what happens is he becomes part of this former family member group that is part of the family group. And so again, once he's entered into that new spousal relationship, he could still receive distributions from the trust without being subject to family trust distributions tax. I do have somewhat of a question about what would happen if the relationship between James and his new spouse ended. You can see the language there is he must be now the spouse of a person. And I question whether if that relationship ended, whether he's no longer now the spouse of a person, which might be a challenge. I'm not sure that that was necessarily what was intended by Parliament, particularly when you look at the equivalent provision where there's been a breakdown in marriage, which causes the person no longer to be part of the family, but to be part of the family group under this former family members classification. In that situation, the ex-spouse, their subsequent marriage or otherwise is completely irrelevant as to whether they fall in or out of the family group. It's merely based on the breakdown of the marriage with the particular spouse in that situation. Similarly, there can be some challenges in relation to distributions that the trust makes to the deceased estate. In respect of the deceased estate, there can be real issues with making a family trust election. You couldn't make a family trust election in respect of Paula being the test individual because Paula's already died once Paula's estate's in existence. And also there can be some challenges with whether you can make an interposed entity election and even if you can, if there's going to be distributions outside the family group, then there might be issues with the imposition of family trust distributions tax as a result of having made that interposed entity election. So there's a lot to talk about. We haven't covered a whole lot of things and I've skipped over a few things, but I'll hand over to Rob now so he can go through some small business concession issues.
Thanks, Caitlin. So what I wish to talk about in the time remaining is some discretionary trusts and the small business CGT concessions. And these small business CGT concessions we know are extremely generous. And in a recent situation I had with a client who's a farmer who ended up selling his farmland and paid no tax on the $80 million capital gain made due to the application of the small business CGT concessions. And whilst the farmer himself was very happy, it was his two sons who were even happier, knowing that this wonderful inheritance was coming their way. The one thing about these small business CGT concessions, for something that is meant to be available for small businesses, they are extremely complex, and particularly where trusts are involved. Two of the main issues when considering these small business CGT concessions and trying to make sure that they apply where we have trusts involved. The first one is to do with connected entities and who are connected entities, because often we need to be able to ensure there is a connected entity or determine which entities are connected with the trust. And secondly, to do with the CGT concession stakeholder or significant individual tests. In this particular session, I'll just assume that most people have some basic understanding of how the concessions work, and I just want to address a couple of particular points. Interestingly, when you're dealing with the small business concessions, the very first thing you need to ascertain is who is the relevant taxpayer. That is, what taxpayer has actually satisfied or made the capital gain, and is that taxpayer you then have to work out who the connected entities are relevant to that taxpayer, who are that taxpayer, significant individuals, etc. In this particular aspect, the connected entity is important for satisfying the $6 million maximum net asset value test, the small business entity test, the active asset test, and also there's additional conditions where the CT asset is a share or a unit. So they're the areas where the connected entity test is important, and we need to determine who are the connected entities. An entity will be connected with a discretionary trust where either the entity controls the trust controls the entity, or the trust and the entity are both controlled by a same third party. So what does control mean in this regard? An entity controls a trust if the trustee acts or could reasonably be expected to act in accordance with the directions and wishes of the entity and or its affiliate. So in the case of control, there are two tests. One, which is one we're looking at now, that is where you've got control of the trustee, or secondly, where there's a beneficiary, special beneficiary test. Note that in this case, you control a trust if the trustee acts or could reasonably be expected to act in accordance with the directions and wishes of that particular entity, or that entity and their affiliates, or just their affiliates. It's only in relation to one trustee. So if you have a trustee with multiple a trust with multiple trustees, if only one of those trustees acts or could reasonably be expected to act in accordance with the directions or wishes of a particular person or another entity, then that other entity or person will actually control the trust and therefore be connected with it. An interesting question arises whether an individual trustee is connected with the trust itself, or whether just the trustee is connected with the trust. Because under this control of the trustee test, it seems to that you require to have an entity and a trustee. In other words, there are two parties. My understanding is that the tax office takes the view that the trustee of a trust is also connected with that trust, though there's nothing 100% certain about that. The typical situation is where you've got a corporate trustee, where you've got one or more directors. So we've got two directors of a corporate trustee. Let's start off. We have a corporate trustee where we have one director and one shareholder. Then clearly that shareholder director is connected with that or controls that trustee because that corporate trustee acts in accordance with their directions or wishes. If you've got two or more directors and those directors make decisions jointly, then you cannot say that any one of those directors controls the trust, because the company does not act in accordance with any one director's wishes or directions. So we've got two or more directors. As long as the directors are making the decisions jointly and independently, having their own votes, then none of those directors should control the trust. Then we had Guttridge's case. Now, in Guttridge's case, we had a daughter who was the sole director and shareholder of the corporate trustee, but she acted in accordance with her father's wishes. Essentially, as the AAT decision stated, that she essentially said that the business carried on by the trust was essentially her father's business, and she just did what father said. So in that case, it was the father that the AAT held who controlled the trust and not the daughter. The AAT found that the trustee, the company, did not act in accordance with the daughter's wishes independently of her father. It was only acted in accordance with her father's wishes. However, interestingly, I would have thought if the father told the daughter how to vote and what to do and what decisions to make, I would have thought that he controlled the daughter and she acted in accordance to his directions and wishes, and thus the company did. But if she was actually still making the decisions, wasn't she also controlling the company, and wasn't she also therefore connected? But that was not was held by the tribunal in this case. The other way for a trust, for an entity to control a trust, is if that entity is a beneficiary of the trust, and for any of the 4 income years before the relevant year in question, the trustee paid to apply for the benefit of that entity, that is the beneficiary, or its affiliates, any income or capital of the trust, to which the amount that beneficiary received was at least 40% of the total income paid in that year. So essentially, where we have a beneficiary of a trust receives a distribution of income of at least 40% or more in any one of the 4 prior years to the relevant year that we're looking at, that beneficiary will control the trust and therefore be connected with the trust. The same applies if there are any distributions of capital have been made in any of those 4 income years. Now note that you're looking at the distributions made in the 4 income years prior to the year in question. So you're not looking at the actual distributions in the relevant income year, you're looking at the distributions in the 4 prior years. And we're looking at distributions of income. And if there is distributions of capital, the same rules apply. So let's look at an example. Let's say a trust carries on a business, say a farming business, and let's say the property, the farmland, is owned by the husband and wife. Now, if the husband and wife want to sell the farmland, then one of the tests they need to satisfy is the active asset test. And that requires that the asset, in this case the farmland, needs to be used in the course of carrying on a business in an entity connected with the individuals who own the farmland. And in this case, that is, we need the individuals to be connected with the trust, because it's the trust that's carrying on the business. So here we have the husband and wife each own 50% of the farmland. Now, the first thing we need to understand here is that the asset is the farmland. In this case, we have 2 taxpayers that own the asset, the husband and the wife. So we need to apply these tests to each of them separately. So if the husband, for example, he's selling his 50% share in the farmland, and so is the wife selling her 50% share. So we need to work out, does the husband satisfy all the relevant tests, and does the wife satisfy all the relevant tests in order to get the small business concessions? They each need to satisfy, or the active asset test, their asset needs to satisfy the active asset test. So this means the trust needs to be connected with the husband, and it also needs to be connected with the wife in order to satisfy the active asset test. So let's say the trust distributed income to the husband and wife 50-50 for year on, year out, then each of those, the husband would therefore be connected with the trust for all those relevant years, and so would the wife be connected, and as a result, the trust would be connected to the husband and to the wife and satisfy the active asset test. But let's say the distribution of the income was less than 40%. So if it's less than 40%, then we have an issue, because remember, to be connected under that beneficiary test, they need to receive a distribution of at least 40% of the income or more in any of those 4 prior income years. So if we just go back, if we have a distribution that's less than 40%, and therefore the husband is not connected with the trust, and similarly, if the wife does not receive any distributions of 40% or more, so she's not connected with the trust, then we need to look at section 152-47, because that can actually save the day. Under that section, it provides that where an entity owns a CTT asset, in this case, the husband or wife owns the CTT asset, and that asset is used in a business carried on by another entity, in this case, the trust, the business entity, the trust, is not otherwise connected with or an affiliate of the husband or wife, and they're not, because neither the husband or wife have received distributions of 40% or more, and therefore they do not control the trust. Then in that case, a spouse and child under 18 is taken to be an affiliate of the individual. So that means, in our example, the husband and wife will be taken to be affiliates of each other. And so therefore, provided their combined distributions from the trust is greater than 40% in a particular year, they will be then connected with that trust in the following 4 years. Now, where we utilise section 152-47, and they are taken to be connected for these or affiliates for these purposes, that means they'll also be taken to be affiliates for the purposes of the $6 million maximum net asset value test and the small business entity rules. So that means they may also be connected, and we need to take into account their assets or their turnover if we're looking at those other tests. It'll also apply for the control of trustee test. So where I said before, if we had husband and wife were each directors of the corporate trustee, and they each made their decisions independently of each other, or made neither sort of was controlled by the other, then in that case, neither of them would be controlled the trustee of the trust, and therefore would not be connected to the trust. But if they are deemed to be affiliates under this section, then as a result, as they're the two directors, then the trustee will be under their control, because it will be acting in accordance with their directions or wishes, because that test looks at, are they acting under the directions or wishes of a director and their affiliates. So it will expand those tests as well. This test applies automatically, so that can also cause some problems. For example, let's say in our example of the husband and wife, let's say for many years, the trust distributed the income 50-50 to the husband and the wife. So therefore, for many years, they did, the husband and wife were connected with the trust. And as a result, as they had been connected with the trust for more than 7.5 years, the active asset test was satisfied. So now they still own the land, and let's say now they're going to sell that farmland. And there's a concern that the maximum asset value test will be failed because their assets are quite large, the actual personal assets that they own. They do not want to be connected with the trust, because if the trust is connected with them, then the trust's assets will need to be taken into account in the $6 million calculation, and that'll push them over. So therefore, the planning this year would be to say, well, in the relevant year in which we're going to sell the farmland, let's not be connected, and let's distribute less income to mum and dad, to the husband and wife, and to make sure they're not connected with the trust. So let's say we distributed 30% of the income to the husband, 30% of the income to the wife, less than 40%. The problem with doing that is that as their combined income is greater than 60%, and as the section 152-47 applies automatically, they will still be treated as affiliates, even though we don't want them to be. And therefore, as their combined income is greater than 40%, they will be connected with the trust, and therefore the trust assets have to be taken into account in calculating whether mum and, in this case, husband and wife, can each satisfy the maximum net asset value test, even though we don't want them to be connected, because we've already passed the active asset test from prior years. So in this case, what we would need to ensure is that their combined income is less than 40%. So it's just a trap to be wary of when that test, how that test can automatically apply. The final thing in relation to looking at these connected entity rules is if you have a year in which there are no distributions, so there are tax losses or there's no net income, and that could happen particularly in farming business, where you could have tax losses for many years in a row, then you may not be able to satisfy the active asset test because you haven't been able to show that the trust was connected to the landowner for the relevant 7.5 years or more, at least half the time the asset's been owned by the husband and wife in our example. However, under section 152-78, it is possible where a trust has a tax loss for a year or there's no net income, that the trustee can actually nominate certain beneficiaries to be controllers of the trust, and that therefore we can satisfy our connected entity requirements in order to pass the active asset test. Please note that if a trustee does nominate a beneficiary to be a controller of the trust, it only applies for that relevant year. So therefore, rather than applying for the 4 following years, it only applies for that year. So you'll need to make this nomination for at least a number of years, or the number of years that you need to be able to satisfy the active asset test. So that's all I wish to provide in this time for the relation to the small business CGT concessions and trusts and the control of trusts. I'd like to thank everybody for attending, and before signing off, I'd just like to say that we have a not-for-profit webinar on Monday that's been held at 12 noon on Monday, this coming Monday. And if you wish to attend that, you just need to go to the events tab on our website, and you can register and attend that presentation, that webinar on Monday. Otherwise, thank you very much, and we'll see you next time we have a webinar. Thank you.